like it started as a new
the career counselor said, it's nice for you to apply to law school, but you really
you're
do
not
need
like
to
in
learn how
a
to
total
type.
rhythm. No, I'm still in
Fall background. Well, at least the counselor said.
Yo, totally. You know what I mean? It's like you're in that period for 6 months. It's like,
That's not for sure.
I know. Yeah, we don't, the folks that we teach,
need some more people.
we need
Chris,
to
sit down.
fathom.
No, like on the side. We need you.
Yeah.
It's been a
There were
migrant.
people somewhere.
Liberty's going Russell.
Okay, cool. Is there a bus coming on something or something?
I have 2 daughters.
Probably all linger and have coffee.
when I'm there.
Yeah, everybody's partying too
Either
hard.
one of
But
them.
did you go out after this?
Felt
No, not
restricted.
so much.
Yeah.
Good.
Although still I'm running on
I don't want to be called out.
Oh, yeah. Oh, my gosh.
Doesn't
I
seem
thought it was
that
bad
long.
on 6.
My wife
Well, at
says
least the days
that,
are
her take on this is the thing that moved the needle more than anything else wasn't the academic side, it was the sports side. She says as soon as Title IX, she says Title IX is what opened up law school.
Really sorry.
You know, where people felt like they could do anything, they could play soccer, they could play all these other things, and so then it just seemed like, yes, we can do anything.
The rhubarb are very special.
Yeah, well,
Very much better than
there's a couch
The woman of that
that
generation.
I plan on taking.
And I think it was really good, but then
Her point of view.
Yeah.
It's like she's kind of like this.
And then things.
I think the bar is better.
Can you go check and see? People on the registry.
Good
Good
morning.
to see you here. You're my first photography event years and
You
years
mean,
ago.
yeah. You got my
You
coffee.
just have this time.
Oh, yeah.
I'm serious about it.
Hey, shot you guys.
My events.
Oh, okay. To look like we know what we're doing? or-
Those are usually seem to be the ones that really get used more than any other.
Nothing because you.
I'm wearing, yeah, look at the lens.
Oh no, are you in charge of it?
Yeah, it helps too.
Yeah.
It just had me on the login page. And I
Well,
did
there's
today.
guest password.
And there is animal log con and then it's bird log.
Oh, I think I noticed a typo here too.
Well, it's only you and me reading it. The only people, this isn't published.
Okay.
My LC wireless
It
is
referenced a rule in the
Oh.
little notes.
Okay, well, that's worth,
And
that's worth
it's
fixing.
the one LC secured.
1 point, it's got 1.18, it's on page 21.
Okay,
Should I see if mine
And it should be 1.8.
okay.
See,
No,
mine
that's
looks
not
like it's
the,
working.
it's a made mistake.
It's a conference app. It isn't getting
Well, it might be 1.8 if you were talking about a potential client. Actually, that might not be a mistake.
No, I
But I think 1.8.
Well, I'm just gonna not
think it's
listen.
like,
Yeah.
When did
Well,
my friend first?
1.8B is about take advantage of the client. That I know.
Okay, then it was, I was probably wrong.
you do things.
I don't,
Yeah, what do you
I said it's pretty
Do
quick.
things.
I'm dyslexic, and so
No, I
things
noticed that too.
like this
The
happen.
security guy just walked by
every
too.
single
The lights are off, like, is it
Well, they
just a
switched
daylight?
off.
Well, I'm not dyslexic, but I
It's
know.
really dark.
I
You can find a timer.
Yeah, I can't.
I was out
can't
there
send
and then it
anything
switched
out
off
of
and I
that.
got really good really fast.
I mean,
Ew.
it's,
I'll, I'll try to address that.
you know, my brain just doesn't see things the way it used to. Like the theirs. I mean, they all register to that. And so it's not like I don't make a difference. It's like my mind just registers.
I don't see it.
I don't
Yeah.
know
Yeah.
that.
Yeah. So then you still think that you're not very smart.
As I am.
Nothing to do
Okay,
with that.
Kathy, I want orange juice, don't start.
But if you're gonna have something wrong, it's not a bad thing.
I thought you were done.
I was, but I
Could
just
be
like,
worse, right?
Yeah.
did not, both have artists to see you.
So how late do you want to wait for?
I was about to ask you. Everybody went to the route.
So
you guys are wondering
I
around.
will, I
Yeah.
have your possessions in my bag, I have 0 cards. We like those.
We do have all of the people online though too.
Yeah.
5 after. And then,
Sure. I think I'm a minute or so and then start up.
Okay.
I don't know. I feel like waiting more, but I don't know.
It's weird.
What do you think?
Well, you guys just let me know.
It doesn't
It's
matter.
like, it says it's connected, it's not connected.
Pick.
Okay, we're giving 1 more minute.
1 more minute.
Okay.
That's-
Do you want us to go down and make an announcement? Because they hadn't started
Liberty
there
went
either.
down there to tell
Check it.
people.
Okay.
It's
I
taken
just
care of.
remembered there's all those online people.
Yes.
Yeah. You want to respect them.
Maybe that's for everybody.
Yeah. I hope this isn't. Well, no, because we did this early last time and it was full.
The bus station.
Oh,
Oh, is it here? The bus is not here yet?
We took a cab.
No show on the bus?
No show of the bus at all?
Well, we left
By the time you
at
left.
7:40.
So you were at that salmon and whatever.
Yeah.
Scott.
Same spot as last year.
Yeah, that sounds like a Liberty thing.
Oh, yeah.
So that could explain.
That could explain the attendance, you know?
I think we had that 2 years ago too, right?
We did.
And then halfway through,
And the whole place filled.
yeah.
So maybe we should wait a little bit.
A little bit, yeah.
Is there a way to tell the online people?
I don't know. Yes.
Right.
So,
is it
you want
like,
to tell Liberty
is
that
it live
as well?
right now?
I think so, yeah.
We're live?
So then they'll have
No,
heard.
if that,
Many things.
see, this is accredited.
Yeah, because once we get the release forms, I think everything's live streamed.
No, I meant just was the link, you know, was it
Is the
active?
link?
Oh.
Apply for your COA.
Are they watching us right now?
That's what I was
It's now
wondering.
all in a computer system.
Can
There's
you
a
tell
code,
them
That would be,
And usually.
yeah, so now I need to
Group.
work.
But it's weird to lecture and.
It might.
little bit.
Or police, and it's not.
Well, the red light on it's recording.
Well,
That
Yeah, when you're
Yeah.
65, you don't
Okay.
have to do it anymore. And my birthday's 3 years in the middle of it, you know, so I'm not really sure what to do. I just figured, go ahead and get them. Get her. And it's hard to get her. We don't have those
You told me where your daughter's living and I've forgotten.
She is in upstate New York. She's a dean of students at a boarding school. She is literally on the Massachusetts border.
Okay. Got it.
Yeah. Although she arrived last night and announced that this week it was supposed to snow there.
Well, I lived in Ithaca and boy, the weather there.
Yeah, I mean, I could record.
Yeah.
When I was at Farmington, that was the closest real town. And, it was a lovely town for the Cornell, but boy, the weather. I mean, there was days when it was so cold that the brakes in my car would not work. With the brake fluid.
And that still live there.
No. No.
Turn the original.
And it's New York, but it's not New York.
I still, yeah.
It's a 5-hour bus ride down to the city.
Yeah. All right.
It's like you live in Appalachia, you know. But that'd be a cool place to either be in a private school.
Yeah, she loves it, and it's a great school. Small.
Yeah. Yeah. That make you feel good. You follow the steps.
Well, yeah, you know, it's funny, when she was a kid, I thought she was going to be a lawyer.
Yeah.
And her sister is a lawyer,
Yeah.
who I never thought
Would be,
would be a
yeah.
lawyer.
So,
It surprises us.
yeah, teaching is good. Teaching is good. My grandmother, who was as poor a person as I've ever known, told me that I had to take up being a cook because then I will never be hungry.
Good thinking.
I mean, this is a depression era person. You know?
And
Right.
then, like,
Yeah, it's amazing how we change.
Everybody.
I know I could look at it.
Yeah, right.
Yeah, she meant it. Yeah.
Tell Ms. Frank to work with his exposure to technology from a young age, so.
You know, except
My grandmother was a cook.
Yeah.
it's gonna
She
help.
was a grandmother with 30
So I can't
Yeah.
say
So
that.
she
Yeah, so you will help you.
so she could always bring
Yeah.
What's up with Samuel? How
Yeah.
big he is.
Yeah. Fun ones. Yeah, you don't make much money as a grade school cook.
No.
She has a single mom too. But she built her own house. I don't mean as a general contractor. I mean, she got a hammer and saw and built her own house.
Wow. Wow. Impressive.
Yeah. So, yeah. That's good stuff to have. Education wasn't high on our list. Knowing how to do stuff.
We know the literature.
Kind of
It's
education.
okay.
Yeah, the conference is definitely a risk.
I was looking for you last night. No, I didn't see you there. A lot of people, it was awesome. How you doing?
Started.
Yeah, let's go
Then the
ahead.
I
bus.
guess,
Yeah.
so.
Sure.
It's like crap.
All right.
Liberty's worst nightmare.
Yeah, okay. We're going to go ahead and get started. All right. So So, good morning, everyone, and welcome to this year's Animal Law Conference Ethics Panel. It's my privilege to introduce this year's speakers for the panel, Professor Steve Johansson and Russ Mead. Steve is a professor here at Lewis and Clark and the director of the lawyering program. Previously, Professor Johansson was a teacher in the Oregon Public School System, an associate at Tedesco and Wilson, a developer and author of a legal writing textbook in Latvia, a visiting professor at the University College in Ireland, and has served as on the board of directors for the Legal Writing Institute. Professor Johansson has published numerous articles on the politics of legal writing, interpreting Oregon statutes, and the ethical limits of storytelling in law. In addition to his specialty in legal writing, Professor Johansson also teaches ethics here at Lewis and Clark and has served the Oregon Bench and Bar Commission on professionalism since 2002. Russ Mead is the general counsel of the Animal Law Coalition and a partner at Allen & Mead firm in Seattle, and a professor here at Lewis and Clark teaching a course on nonprofit animal law. He served as the general counsel for two of the nation's leading nonprofit animal sanctuaries. He oversaw thousands of volunteers for animal rescue efforts in the wake of Hurricane Katrina. And he has worked with rescues in a variety of puppy mill, hoarding, dog fighting cases, including the Michael Vick case. In addition to his extensive background in animal advocacy work, Professor Mead has taught business ethics and has given lectures on professional ethics and ethics in animal law. He recently presented CLE programs on animal law ethics for the New York City Bar and the Nassau County, New York Bar. Please join me in welcoming these exceptional professionals for an engaging discussion of professional ethics in animal law.
Open with a remark or two?
Well, sure. It's a pleasure to be back again at the Animal Law Conference. What we've got in mind today is hypothetical a story in three parts. I always like stories, and so we'll. And not surprisingly, they raise ethical issues. So we'll talk about that. But it's great to be back. I want to say.
Oh, just all the same thing. It's great to be here, and not that I have seen everything that has happened, these hypotheticals in one place, but I have seen everything that is here one time or another. So there's a practical side to this that we hope we bring to the table, which is, I think, very important when we're talking about professional responsibility. So with that, Steve is going to start with the first section.
Okay, I'm going to stand up.
Good.
I can't teach sitting down, and that's my home here, so I have to stand. So what I'm going to do is, the room seems to be listening this way also. Sorry about that. I will just read you the story, and then I'm going to turn it over to Russ to start the discussion about what sort of ethical issues might be involved. I hope that as we read through, you will start to recognize at least some ethical issues before Russ even talks. So here's our story. It's about an attorney named Billy Miller. She's an attorney who volunteers for several animal nonprofits. Her main practice area is in federal immigration law. She lives in Oregon, only a few miles from the Washington-Oregon border, much like right here. She's outraged by the recent news that a chiropractor named Milt Gross, living in Washington, went to Africa and killed a lion named Sid. Sid lived on a game preserve and was lured out of the preserve and killed by Milt Gross. Billy attends a meeting of the anti-hunting group named the No Hunting Coalition. They object to the hunting of any animals. And the executive director of the No Hunting Coalition, Sam Smith, knows that Billy is a lawyer and has asked her if a state law could be passed that would ban taxidermy in Oregon, as well as the display of any mounted animal heads taken from this state forward. Billy says she believes a law like that would fit in the state's hunting statutes. Actually, Billy's never read the state hunting statutes. Billy volunteers to take a state representative, to find a state representative who might be willing to sponsor the bill. She tells Sam, the executive director of No Hunting Coalition, that she has some leverage on state rep Sarah Solo. Billy knows Representative Solo is having a secret affair with Billy's brother, which apparently isn't all that secret. But Billy approached Representative Solo with the idea of a statewide ban on taxidermy and a display of animal head trophies. Sarah told Billy, "You've got to be crazy. There's no way a ban on taxidermy would ever pass in Oregon. Also, have you ever been outside of Portland? Every gas station, store, and even some churches have mounted deer heads on their walls. You might ban mounting African lion heads, but never a ban on mounting deer heads, pheasants, and whatever else they shoot out there in cowboy country." Billy then attends a meeting of the Friends of Sid. This is a newly formed Oregon nonprofit committed to ending African shooting safaris. At the meeting, Billy says, "I've talked to the state legislature who may be willing to sponsor a bill that would ban mounting or displaying African game heads. It doesn't look like the bill sponsor would be interested in a statewide ban on all taxidermy, but we may get them on board for poor animals like Sid. Would you like me to contact the potential sponsor to see if she would sponsor a bill like this?" The executive director of Friends of Sid said, "In the name of Sid, go for it." Then the discussion turned to ways to get the hunter, Milt Gross, who killed Sid. The discussion focused on ways to try to have his chiropractor license revoked on the grounds that luring a defenseless lion out of a preserve proved that he lacked moral standing to keep a chiropractic license in Washington. As the crowd chanted, "F Milt, F Milt, F Milt," Billy said she would gladly take on the case. So, Russ, do you see any issues there?
What I'd like to do is have folks talk amongst yourselves for a few minutes and see what you can ferret out of this. So, what rules of professional responsibility? Not that you would know the rule numbers, but
Come on, chapter and verse.
yeah, where has she gone astray here? Or where might she go astray? So, talk amongst yourselves for a few minutes.
Choosing her law school.
Yeah.
Where do you start?
Yeah.
No leverage thing. I think really they should just take it on. So, never mind that. Need to do it. Yeah, I didn't see it. Oh, that's always true. Yes. Is there a state's orders thing? Yeah, he said that. I was like, maybe I should have been paying attention. Sam Smith?
Right. But I think she's representative.
Oh, okay.
Yeah. And obviously,
I'm a visual learner. I really am. It's a terrible thing actually for law study. Because I don't. I go over and I started thinking about Cecil and Lion Eyes and Russ, I'm a visual learner, so I'm like looking at the lines instead of listening when you guys are talking.
Well, at least we're keeping folks engaged.
I'm engaged.
We're thinking live.
No, that's okay. I like it. So
and who wants to call
we're supposed to comment on the legislation for the constitutional issues. You should know better from the start. This is true. No, they're totally. Yeah. So I don't know. I think that she did about it. Yeah, legislature. That was the leverage. Yeah, that she was needing that leverage.
Oh, yes, to file claims.
That's my thing. We're not doing this. So bad. So bad.
I don't want to get into discussion, right?
They make the terms of representation. Like the benches. She has to celebrate because she's happy.
Yeah, let's go ahead and start. All right. So we're going to come back as a group and talk about what issues we've seen. So what do we think? Where has she gone astray or possibly gone astray?
Choosing her law school, sir.
Choosing her law school, just right off the bat, that wasn't a good choice. Well, I've never heard that before, but I like that. I'm going to remember that. So besides not having Professor Johansson lead the class, what else do we see? Just a topic. Go ahead.
Can she go after the chiropractor's license? Realistically, I don't know what the Practice Act says,
Yeah.
what the rules that govern ethics say. So I don't know if it's prudent or if she's able to do that.
That's a really good point. So she's saying her client has asked her to do something. Do we think she knows the answer to that question? Probably not. I mean, I suspect nobody in this room would know the answer to that question, and nobody other than a licensing lawyer would have the answer to that question. So, what about competence in terms of taking on a new engagement? I mean, can you say, yes, I'll represent you in something I know nothing about?
You can.
You can.
But you've got to get up to speed.
You got to get up to speed. So what types of things would that involve in this case? I mean, what should she do either while she takes on the representation or as she's taking on? First of all, does she have to get up to speed before she signs up? No.
No, but she ought to let them know.
Yeah, there you go. Yeah, say, hey, I've not looked at this before, but I've done other licensing, or I do regulatory work, or I do whatever, and I would be glad to look at that, but no, I don't know the answer right now.
And I believe you said she's not licensed in Washington, correct? Only in Oregon?
Yeah, that's a bit of a problem that's going. We'll hold on to that because that. No, we'll cover that now. So what about that? I mean, now we seem to be able, at least in our minds, to do work in multiple jurisdictions. I mean, the law seems to be getting more and more homogeneous to me, and there's all of that federal work that is the same all over the country, but we're licensed in a particular state. So, what should she do? Should she take on an engagement like that, or what should she be doing?
Well, she needs to know what the rules are in the state in which she's licensed and the state in which she wants to
Right,
work.
both. I was looking at a situation about a month or so ago, and it became important what the rules in both states were, and they actually conflicted, which then creates a choice of law issue about ethics, and there's even a rule of professional responsibility on that now that's talking about, I'll just give it to you, if there's a conflict in the rules and there's a judge involved, these aren't the exact wording, but the way I read it, if there's a judge involved, you defer to the state that has the judge. So this can get pretty complicated, even in terms of not the law itself, which we've talked about, but also the rules of professional responsibility in those particular states, and they might not even be consistent, even if the states generally follow the model rules. They may not follow this particular, model rule. All right, so what else do we see?
I mean, the leverage that she said she had.
The leverage.
I mean, now maybe she didn't use it. That's unclear from the statement of facts.
Well, actually, and I happen to know this rule. I guess that's why I'm standing up here. But there's a rule, 8.4, that says you can't even imply to properly influence a government official. It's got to be a government official that you can influence. So just implying that, yes, I've got something on that state representative, suiting a state representative as a government official, my instincts tell me they are. I've never looked that up. But if they are, you can't even imply that you've got some way to, muscle in on them to get them to do what we want. Now we see this a lot is in, of course, criminal cases, where there's prosecutors. But in this case, we're looking at a state representative. So that implication even could and probably is a violation of model rules. What else do we see?
The conflict of interest issues in the terms of her representation.
Yeah, the conflict of interest issues. One of the things that I see out in the real world a lot is conflicts between the views of nonprofits on what to the outside world would be, very similar situation. So you've got two organizations that, both believe in anti-tethering. You should not tie up dogs. One group will say that you should not tie up a dog for a minute, and if we can't get that law, we don't want any law. And there'll be another group that says, well, as long as we can get them off the chains some, we're okay with that. And so you can have two animal welfare groups, both sole purpose is to get dogs off of chains, and both have total opposite views about a bill that they would support or not support based on their philosophical views of the issues. Anybody ever seen these conflicts before? And everybody in this room is smiling and laughing because yes, and these conflicts are real and they're entrenched, and it can be a real problem if there's a conflict. So is there a conflict between the organizations here?
I don't think we know.
We don't know. One wants, okay, we'll hold on to that thought. We've got two different groups here, right? Go ahead.
Well, the one group seemed to, when they first approached her, say, look, we want to ban on all of this stuff. And she said, well, I think I can do that, knowing nothing about it.
Right.
Federal immigration law. She says, I think I can do that. Then she goes to the second group and says, well, I think I can do just a part of that.
Mm-hmm.
And so that seems to me that when we've gotten a conflict, she's representing that first
Good.
group and says, we want everything gone, and that's what she agreed to take on. And then she directly goes to the second group and says, look, I'm not going to take away everything, but I think we can get a part of it. Well, then she's got two different agendas.
So we do have a conflict. Could this be?
Perhaps.
Pardon me? Perhaps.
We're going to get to the rest of the story.
I know the rest of the story keeps going. Yeah, we're ahead of ourselves a little bit. So again, if we're not licensed in the state, what do we do if we do want to take on going after the chiropractor and we get up to speed on it? What do we need to do? I'm sorry?
Associate counsel.
Associate counsel, yes. There's even a role of professional responsibility on this. You bring somebody else in, they're the counsel of record, you're there to help them, the court knows that you're there, the court knows that you're not licensed, and then you work together and then you're able to involve yourself in the engagement.
Building on the sort of competent representation issue, given that she's now acting sort of as a lobbyist, I'm sure there's filing requirements with the state legislature or at the federal level to be an officially registered lobbyist. And I'm not too sure about Oregon state tax law, but at the federal level, there's a huge difference between a nonprofit petitioning the legislative and the executive branches for various things that could get all sorts of filing aspects of the IRS, et cetera, in trouble here. So.
Right, and certainly, and I do know about the lobbying, and yes, I mean, once you trip into that world, you're acting as a lobbyist. I mean, and lawyers are lobbyists, but non-lawyers are lobbyists. And so that brings up something to think about in all of these types of situations. Are you acting as a lawyer? Are you not acting as a lawyer? Are you covered under the rules of professional responsibility as a lawyer when you're doing lobbying? Those kinds of things need to come to mind because lawyers more and more are being called on to do what maybe 30 years ago lawyers wouldn't do. I mean, we are branching out more. We're these people that do lots of different things that involve the law, as opposed to go to a law firm, file lawsuits, represent clients. We're doing all kinds of things. So we have to be mindful. We need to be mindful of that. See what we have before moving on. I think that's it. Other comments about this segment?
Well, I've got.
You've got it. Professor.
Well, one question is, does she even have clients yet? When does the lawyer-client relationship form?
She has a responsibility because they think she's their lawyer.
Exactly. The lawyer-client relationship forms when your client reasonably thinks that it does. As I tell my students, that could be at a party. And it could certainly be, in this context, it seems to me that she has formed a lawyer-client relationship. Apparently without doing anything like, conflicts checks or all the other things that would be appropriate to do in forming that relationship. So there's an issue as well.
So be really careful of this. In fact, when I was speaking to the New York bar, they wanted a whole section just on how can we avoid becoming somebody's lawyer when we're volunteering for a nonprofit. I mean, they said, if you can put together an hour of that, we'll fly you back out to teach us that. Because, you know, you show up in a meeting, somebody asks a question, you're the lawyer, you're the smart person in the room, and you answer, and boom, now do you represent this group? And, you know, you probably weren't signing up for that when you saw that this is an interesting meeting and you showed up and had a glass of wine and instantly became their lawyer. Go ahead.
So what should she have done then at the No Hunting Coalition when this individual approach starts? I'm thinking about this ban on taxidermy. What do you think about that? How does she avoid becoming potentially the lawyer?
How do you avoid?
I mean, is it enough to just say, I'm not offering you legal advice here, and, you know, and start there? I mean, just with that statement, is that enough to cover her? Or?
What do you think?
I
What do you
don't
think
know.
What do you think if you're up in front of the disciplinary board?
And that doesn't hold then. I mean, then maybe you can follow up with a written email that was nice talking to you again. I'm not offering legal advice.
Yeah,
I don't know.
I think you get into trouble anytime there's a but, comma, and then you move forward. But what I have seen that, in my view, is effective is to send them to resources. There's some interesting articles by the ABA. You know, I'd be glad to send you a link to those materials. Something along those lines where you're not the speaker, where somebody else is the speaker. There are ways that you can help out folks in a way that doesn't create, you know, that relationship, which, you know, I think most folks want to avoid, unless you want to be their lawyer. And then if you're their lawyer, you know, then you got to decide, is this the group in this field that I want to represent? You know, maybe it's not.
Is there a distinction between an individual at the meeting that comes up and asks your opinion and the meeting as a whole that you're addressing? Is there a difference in, you know, how that starts relationship?
What do you think?
I think there is.
Well, the individual might not be able to speak for the organization. They might not have that kind of authority. And so there's at least a potential to have a different outcome if you're talking to the individual. And because I would assume that if you're in the meeting as a group, the sort of indicia, right, authority is there. And it's not necessarily, but it could be.
So the person, that individual at the meeting who comes up and says, well, what do you think about this, may not necessarily be there, may not be coming to you as a representative of the group as a whole.
Right.
But just as on a personal level, you know, deferring to your knowledge that they may not have.
Which
So
would mean,
is that,
yes, which would mean you would be picking them up as an individual client and not a.
Then is it sufficient to say, you know, that I'm not establishing a legal relationship, but in my personal opinion, is that enough?
I think anytime you got a but in there, I think you're in trouble. I mean, that's just my rule. Just don't say it. If you don't want to represent the folks, get them to some resources through an email later.
Could you at least say something like, well, in a hypothetical situation where a unnamed client was shot, could you think that would work better so that you were addressing the direct?
The way I always look at this is you're in front of the disciplinary board that's looking at a 6-month suspension of your license. So how are they going to view it? How are they going to view it? And as soon as you start thinking in those terms, I think you start getting pretty conservative in the way you approach this when your own license is on the line.
And in this situation, I think when they start asking questions, her first response is, I don't know the statutes. I don't know the law. And in order to give you any advice, I would have to do some more research. Maybe you should set up a meeting in my office and we can talk about whether you want my services.
And do a client intake form, and of course do the conflicts check, and you know, who knows what you'll find in the conflicts check. There was a hand up.
Yeah, well, if what you're talking about is you see someone, maybe it is at the meeting of the nonprofit organization, or maybe even at a cocktail party, which is a more extreme situation, and they know you're a lawyer and they ask you a question. It would never occur to me to say, I'm sorry, I can't answer that because I'm not giving you legal advice. I don't think anybody reasonably thinks that they're becoming a client because they engage me in a conversation. I would absolutely say, I don't know anything about this, assuming that was true. Off the top of my head, this is what I think. I did that for 40 years. I never came before a disciplinary board. It just strikes me as very harmless.
There's, and I'm sure the professor knows examples as well. I read one disciplinary report. It wasn't in this state. So this is disciplinary board going after a lawyer, And what they said, and the reason I quote it is because it's the most extreme thing I've seen, said, if somebody asks you a legal question and you give them a legal answer, you represent them. You have just picked up a client.
But I'm not purporting to give a legal answer.
That's great.
I'm saying
I
I
know.
don't.
Well,
No.
I think that you're probably right. As a practical matter, do lawyers ever talk off the cuff? Of course they do.
We're human,
Is it a risky practice? It could be. And part of it is I think you have to know the context, the person you're talking to, and what their reasonable expectations are. And boy, you better put a lot of caveats there. And of course, remember, if it ever comes back, the benefit of the doubt of that conversation that wasn't recorded in any way is all going to be toward the client. If the disciplinary board is looking at this, somehow it comes up that you gave them, they came to you and said, here's a problem, and you say, well, gee, off the top of my head, that doesn't sound like a case. You've just given them legal advice, and if it turns out there is a case, that you could be
Well, if
liable.
they're sitting in my office, that's one thing.
Right, but no,
And I'm
even if
totally
you're
not
sitting,
sitting in my office.
if they're talking to you, they don't know that it only counts when you're in your office.
Yeah.
So, I mean, yes, as a practical matter, I think you're right. Lawyers do that. I think that there's at least a risk there.
Yeah.
That, have I done that? Yes, I have. But I don't recommend it.
Yeah, using that standard then, if you talk to a doctor at a party and said, I got an arm ache here, what do you think that could be? Then he says, well, it could be arthritis. Then under that theory, he's now your doctor. You ask an accountant, I just did my tax filings. I wasn't sure about Schedule D. What about line such and such? Yeah, then he's your accountant. I don't think that kind of relationship, unless you actually come into an agreement. Otherwise, people who are professionals don't have the right to speech, basically.
Well, first of all, I have no expertise whatsoever in medical ethics or what their obligations are, or accountants. But
Oh, you just said but.
yes, and I'm not giving you legal advice here, so I don't know is the answer to that. But I do know that the lawyer-client relationship forms when the client reasonably believes it does.
But it's not reasonable in some circumstances.
Well, let me suggest that what a disciplinary board is going to see is reasonable for a client to believe is a lot different than what they think is reasonable for a lawyer to believe.
And
We
that's
know
why
that
we
we don't think we formed a client relationship, but if they do, and if we've given them legal advice, I mean, there are cases of somebody coming to a lawyer and the lawyer saying, "I'm not interested in your case. Go away." Formed a lawyer-client relationship. "I don't think you have a case. Go away." That's more accurately what they allegedly said. Because they did have a case, but that "I don't think you have a case, I'm not interested in it," was legal advice. The client thought so. They missed a statute of limitations.
Well, I think the other problem is that from a pragmatic perspective, the client is relying on the information. And I think the difficulty is when lawyers talk off the cuff, as we do, it's really difficult to know what the consequences of that are going to be. So I've talked to people who've said, "Oh, well, I just talked to so-and-so, an attorney I know, and she or he said this." And I was like, probably, like, when did you have that conversation? And there was like a cocktail party kind of conversation, and it was not accurate. But it wasn't, people, they weren't being careful. And
I think that's well said. Is that's the problem? If you're a lawyer and you're telling somebody something, they think
there's a reason they're asking you.
there's a reason they're asking you, and not the accountant, because they know you have expertise, or they believe you have expertise. Because of course, if you're a lawyer, you know all the law.
Yeah.
Well, if you suddenly said that, here, that'll be $95 and handed them a bill, they would be shocked.
Yes,
and
they would.
Well,
that's really what a client relationship is, where you have an agreement to pay for services.
No.
yeah, that's why we're here
Money's got nothing
talking
to do
about
with
this. Yeah.
No, you form a lawyer-client relationship whether you charge a dime or not.
Look at all the volunteer work we do. And with that, we're going to move on to the next segment. We've, by the way, this smaller group, because the bus didn't come, it makes for great discussion. So this is you're not missing out by the room not being full. I'm gonna read, and Steve's going to moderate next time. Billy goes back to the No Hunting Coalition and gives them the bad news that any bill that would ban all taxidermy would not pass. Billy then reveals that Friends of Sid Group would like to pursue a bill that would at least ban African big game trophies. The No Hunting Coalition executive director says, "We can never get behind a bill like that. In terms of pure carnage, lion hunting is nothing compared to the thousands of defenseless deer killed in this state. Go back and tell that home-wrecking state rep sponsor the bill we want, or expect to see her name listed on cheaters.com, which is a website where cheating spouses are outed to the public." Billy responds that she will talk with Steve, the rep, or talk with the state rep, but does not think that the threat of reporting her to cheaters.com will result in her sponsoring a complete ban on taxidermy. She tells the director of the No Hunting Coalition that they should modify their all-or-nothing stance against taxidermy and work for incremental advancement of animal rights. Billy is fed up with the fact that two different nonprofits that are both opposed to taxidermy won't work together on passing a bill. She makes the following post on Facebook, which is never good. "I am just done with volunteering for animal nonprofits. I like animals better than people anyway." She never investigates filing with the chiropractic board a complaint against Milk Gross. She has no additional contact with Sarah Solo, the prospective bill sponsor. So, Professor.
So, do we have any issues that we see there?
It implied, for one, when the head of one of the organizations said, "I will tell that home wrecking so-and-so," that implied that she's kind of further disseminated this private knowledge that she has. That would be, say, does that count for anything? That now she's giving other people, her potential clients, leverage over the sponsor of the bill?
Well, to the extent that she's suggesting that the organization, in one way or another, is going to be harassing this state representative, or blackmailing, might be another way to put it, yeah, that seems problematic. You can't, you can't, assist your client in breaking the law, and I think blackmail probably falls within that. So yeah, that's problematic to say the least. Now she did say, I don't think it's going to work. The threatening her with blackmail is going to. There's a couple of sort of issues there.
Here, there's a clear conflict between two clients.
Okay.
You can't represent them one zealously over another. I just think there's a built-in conflict.
Where's the conflict?
Because they have two different agendas and want her to do conflicting tasks. She can't do both.
She can't do both. She can't advocate for a complete ban as well as a limited ban. I think you're probably right. However, there is the idea of positional conflicts, which allows you to represent clients that have different points of view. I'm not sure that.
With their consent.
Pardon me?
Only with their consent.
Well, for positional conflict, it comes up, again, I think in our context, the answer is, yeah, I don't see how you can you can't reconcile these. And what you're trying to do is pass legislation that would be against the interests of one organization or the other. But, for example, you can represent, economic competitors. That's okay. And also, you can go to one court and say, this is what the law should be. The law should be X. And you can go to another court, at least in a trial court, and say the law should be not X, representing a different client. And those conflicts, that's okay, that's not a conflict. It seems kind of weird, and it might not be a good business practice.
It just seems glaring to me, because on one hand she's saying, I'm against all taxidermy for client A, and I'm pro-taxidermy for local game, but not for lions. So it's like it's totally pro and con to me.
Well, that's true, but in advocating for our clients, we do not necessarily endorse our clients' views. And so when you say, I'm for this, no, your client's for this, not me. I'm just their advocate. So in that sense, that's why you can have positional conflicts.
But I think the issue, the conflict arises only because the one group that wants the total ban is totally opposed to the other approach. Those approaches aren't necessarily inconsistent, and they could go hand in hand. But the one group says, absolutely not, we won't have anything to do with it, we don't think this helps, and therefore I don't see how you could represent them.
Yeah, I think that I agree in this context.
As well as an advocate, she also has a role as a counselor, especially in such a political arena. I mean, she may very well have the obligation to inform and pressure them to think half a loaf is better than none. I can't get this one for you, but strategic tactical decisions could make me allow this to occur.
Certainly. We're counselors, and we can talk to our clients and say, what you're trying for just isn't realistic. Let's try to, you want to stand on the street corner and shout, or do you want to get something done? And those sort of counseling is certainly permitted under the rules. There's really interesting questions about how far we go in terms of, respecting our clients' autonomy and achieving what they want rather than what we think is in their best interest.
Well, presuming there is a client relationship that's been established with both groups, she didn't notify them of the end of that relationship. Posting it on Facebook is not going to the group and saying, I'm withdrawing whatever assumptions you have that I'm going to represent you, especially in the case of looking into the issue in Washington, because she said that she would do that. That was a very clear statement on her part, that she was going to follow through, and she did. So you have a big breach of duty there.
Yes, absolutely. This is not how one withdraws from representation. So clearly that was, if she thought she's withdrawn, she hasn't by posting it on Facebook. And it was interesting, as soon as I heard the word Facebook, we heard a collective gasp, which was good to hear. I have to say that, many of the students that I'm teaching now are social media is just part of their world in a way that it's still not part of mine. But they have different ideas about what social media is all about. And of course, law practice, Facebook, those sort of things really should stay pretty much separate.
Steve, I'm kind of a dinosaur. Are there any new rules of professional conduct or professional responsibility that govern social media?
Well, not specifically. And I think what we've seen is that the rules that we already have been adapted to govern social media. One of my favorite stories about social media, which is something to keep in mind, is not only do we have to be careful about what we post, you got to be careful what your client does also. I talked to a judge a while back who was having a pretrial settlement conference, and the defense lawyer asked the plaintiff's lawyer, do you know that your client is blogging about this case, including conversations she's had with you? And it was news to the plaintiff's lawyer that her client was doing this. And then, of course, the judge says, well, I want to see everything that's been in these blog posts, because nothing in there is protected by the attorney-client privilege. You've just waived that by broadcasting it to the world. So there's a good lesson for all of us to take to when we're talking to our clients, because they don't know about their use of social media also. So, we still have client confidence rules, and that can pretty easily transfer to social media. And certainly we still can't trust social media as our way to publicly withdraw from our clients. That's kind of silly. So.
Even if she had withdrawn, as she should have done, in writing, if I ever was your lawyer, I'm not your lawyer anymore, it may be too late because they think that she represented them, the one group that is opposed to all taxidermy, and therefore they say, you can't, out of your duty to us, go and represent somebody that is doing something contrary to our interests.
Right. If there is a conflict here, and I think there's a pretty good chance there is, then the solution that she may be forced to withdraw from both.
From both, exactly.
Right. If you have a conflict, you don't get to choose one over the other in most circumstances. You have to withdraw from both if you were representing both and a conflict has arisen. So that's one way she could withdraw because if she'd be forced to. She could also withdraw if she truly does find her clients repugnant. And I'm not sure from what she's posted on Facebook it rises to that level, but that's another basis for withdrawing.
Steve, we should,
We need to get to the last
segment.
Last segment. Okay. So, there's an end to this story.
There's more.
There's more. Yeah, and as I mentioned to Russ, I really like the way the story goes because it just gets worse and worse. See if you can see any problems here. Billy is attending a celebration of Sid the Lion's life at a local park that is put on by Friends of Sid. Cindy from Friends of Sid found they needed another 100-foot-long extension cord to plug into the portable PA system. Cindy remembers Billy as the lawyer attending past meeting and calls out, "Hey Billy, we need a 100-foot extension cord. Would you go out and find one for us?" Cindy grabs a handful of cash from the donation jar and handed it to Billy. Billy put the cash in her wallet along with the $250 in cash she received earlier from an immigration client, $22 of her own cash, and a $100 bill she keeps stashed behind her driver's license. Billy buys an extension cord with the cash from her wallet, returns, and then helps set up the PA system. The gathering starts out spirited. There is plenty of Oregon India Pale Ale on hand, along with a bong in the shape of a lion's head with the finest Oregon organic marijuana. The mood turns reverent when Cindy reads animal quotes to the gathering from Socrates, Gandhi, and Joyce Tischler. After the readings of the celebration of Sid, the lion continues. For some, the mood turns from celebration of Sid the Lion to anger. Cindy, the event organizer from the group Friends of Sid, shouts out, "Let's go to Milt Gross's medical office and shoot out his windows. Then he can feel what it's like to be hunted." Billy yells back, "If you go, use bricks, not guns. There's less jail time if they catch you." It was hard to tell if either Cindy or Billy is serious. At the Sid the Lion celebration, Billy meets Zach Murphy, a board member of Friends of Sid and a retired ship captain. They hit it off famously and talk for hours while sitting around the bonfire of life lit in honor of Sid the Lion. At the end of the night, Billy had more to drink and smoke than she was comfortable with and asked Zach to take her home. Well, Zach did more than take her home, as Zach and Billy had I'll call it an adult sleepover.
Got it. So rather than break into groups, let's just roll into this. What do we see any issues here?
No.
Oh, good. Okay, we're good. Good.
Is there any sentence that doesn't have an issue?
Yes. Well.
So commingling money.
Yeah.
Commingling money. So of course we all know you can't commingle the money. I just have a best practice to pass on. Don't ever take cash from a client, period, unless it's a cash-paying client. You give them a receipt and it's for your services. But don't ever do this. The better way to do it, as we volunteer for nonprofits, is for her to go out, buy the extension cord, submit a receipt, get reimbursed like some other volunteer or like some other expense. As soon as they start handing you cash, you're in trouble because you're supposed to safeguard it, you're supposed to segregate it. It's hard to do when you're taking a wad full of cash for anything. So best practice is just don't do that.
We also didn't hear that she returned any additional.
No, we didn't. Yeah, we didn't hear about that piece.
Conveniently, the price of the cord was exactly what she grabbed out of the jar.
Yeah.
Still in trouble.
And just think of the record. I mean, do you really want to then submit back a bill? I took $25. It was $24.20, and here's the change. I mean, you write a check. I mean, no, just don't do that. Just pay for it and get reimbursed if they're going to reimburse you. What else do we see?
Possibly lawyer having sex with a client.
Right. So there's two issues here. One is, in the rule is that you can't have sex with a client who you've not previously had a sexual relationship with, which a lot of folks don't realize. But I think that makes some sense. If you want to go represent your girlfriend on a traffic ticket, it makes sense that you can do that. And so that's what the rule is set up. The funniest thing I think I've had in the classroom was discussing this very topic, and one of the students, in all seriousness, said, "Okay, when you first start volunteering for a nonprofit, you should have sex with everybody you think you might want to have sex with before you represent them, and then you're covered." And which launched a whole discussion, which folks in these settings always laugh at, and they had a serious 10-minute discussion about whether that was, good or not. So, so what else? What else do we see? Yes.
I'm not from Oregon, but I assume Oregon follows the model rules because the rules are actually different in California.
Is it?
In California, you just have to be the sexual relationship just has to not affect your competence to represent.
Okay, that would be a modification from the model rules, which brings up something. We talk about the model rules here because folks fly in from all over the country to attend this. On anything, if you really want to know what the rule is, you need to go pull the rules. And for your state, because even though they say they're model, there's lots of variations.
I can also tell you, even though it's legal to have recreational marijuana in Oregon, it is still illegal federally, and a lawyer shouldn't be doing it.
It is. So there are some opinions out. You want to cover?
There's a couple of things in Oregon about the marijuana. First of all, no one is allowed to do it smoke it in public, so that's another issue. Oregon just adopted a new model or new rule that allows lawyers to advise clients about Oregon's marijuana laws. But if you do so, you must also advise them about federal law and any laws that might apply on Native American lands. But I had an interesting conversation with people from the bar, and this is absolutely not an official statement of the bar, but just sort of a what does this mean? Because it is still a federal crime, so lawyers can advise their clients, but can lawyers get into the marijuana industry, which is, by the way, huge? And could you invest in that or participate with your clients? And the advice was probably not, because it's still a federal crime to do so. And the rule doesn't expressly permit you to, commit a crime. You can only advise your clients as to their use. And which it seems to me that you would also argue that would be true about consumption of marijuana also. Still a crime, although whether it reflects on your ability to practice law is a different question, I think.
But one thing that it might affect is your competence. And so just because you're allowed to smoke in Oregon doesn't mean that you can be at a deposition and start eating the brownies because the deposition's going a little slow. I mean, when I've talked to the bar, they've said that's where they're going to see the issues is in the competence issue when people have been smoking marijuana and then giving advice.
Well, following up on the business interactions with marijuana, you should also be cautious about maybe even accepting any money from these clients if it came from a legal source, which under federal guidelines can be seen as racketeering, money laundering. Especially if it's cash, too, because then there's reporting requirements when you exceed $10,000
right
transaction.
Yeah, and all of those issues. And we know that the marijuana industry is having real trouble with banking.
Well, I can't cite chapter and verse in the model rules, but I'm quite certain that advising a client to commit a lesser crime rather than a greater crime.
Well,
that's advise on legal consequences.
Right, that's an issue. You can't advise him to commit a crime. Well, you can't advise him to commit a crime. You can't assist him in committing a crime. You can inform them as to what the law is. And so you say, if you're going to rob a bank, rob a state bank rather than a federal bank because the sentences are less, but don't rob a bank. You're informing them as to the law. Maybe, but I think you're probably in trouble there. And this one, if they were serious, bad idea.
So with just 1 minute left, let's see how all of this ends. So a bill to outlaw taxidermy of animals killed outside of Oregon was introduced, but was stalled in the Agricultural Committee. Supporters vowed to have even more support next legislative session. The hunter, Milt Gross, found it impossible to continue with his chiropractic practice or even live in the state of Washington. He was last seen working as a night cashier at a gas station in North Dakota. Billy sold her law practice. Billy and Zach Murphy now sail around the world exposing illegal ivory merchants and are frequent speakers at animal law conferences. So with that, thank you. We hope we've exposed some things for you to think about for professional responsibility.
We started this conference on a high next week.
Thank you.
Where are you living? Oh, you forced me to keep this.
I find out. And the other thing, they know everything. But I've also read
That is
that
good.
Jeff
That's always the biggest thing. You're representing, so.
So
it looks like that. I was like, so is it going well? Yeah. So excited you're there.
Yeah.
No, he's not.
All right, see you soon around.
I'm going to do some work. My daughter and both of my daughters are volunteering. It's something that they've been doing for years. Every month they volunteer work. And Christmas they give us a calendar, pictures of all the volunteer work. Thank you. Her favorite Christmas gift. And so when they're in the same town, they always
Yeah, I love your bag. I want one, of course.
That's something.
Yeah, I was just that in
Their mother raised good people.
Well, it's,
yeah, I remember my father said.
And, you know, and there's always
well, again, thank you. Thank you so much.
I don't want to be
All right. Well, enjoy your day.
I took a year off.
Particularly this evening.
yeah, it's nice to have her in town.
I was just agreeing.
Okay, take care.
Did I say that your daughter works in upstate New York?
Hey,
She does. Darrow? No.
Just, I was going to follow up, and I know that there was a lot to
What's your
cover,
dad's
and I admire the way the two of you put this program together. That was very engaging.
well, because it's always,
The dean of
these
students.
have a tendency to be less than exciting when we get our credits, and so we come up with this years ago as a way to make it engaging. So.
Well, you certainly
There aren't many
succeeded
people that
with
have
that.
heard of
But just a variation on it.
No.
I work for a nonprofit, and I get emails from all over the country saying,
Oh, that's
oh,
great.
this
So
happened
how
to
long
me,
have you
what do
been
I
there?
do? And I do as you advise, and just say, you should contact, the police, the local attorney, But the other thing I do is I sometimes cut and paste a section of law from your state that's relevant and say, you should take this section to an attorney. Is that beyond, I mean, I
I
can't
think
have a
that's on the
relationship.
edge. I prefer that you.
But I also start every correspondence by saying, I'm licensed only in the state of Illinois, and I cannot represent you in any, legal issue.
I prefer the link to their stuff rather than cut and
Like he has
paste.
his master's in
Okay.
business, so I think that's why he's doing
Yeah,
the site
but
and the health class.
at least you're pointing it out. So.
He also
Okay. I thought that was probably okay, but I sometimes do
I think you're on the edge.
the presentation of what the actual law is, or I send them a link to, an article or something.
Yeah, because
but-
clearly you can steer them into resources. I mean, that's clearly something you can do. And so if all of those are, here's some resources, here's the numbers for this person. Here's
I never give,
decides.
never
Yeah,
give
we were there,
recommendations for an attorney. No.
She's been there.
I sometimes say
for-
try
for
contact.
groups.
Oh, okay.
Like here's the lawyer referral group for your
We went
group.
back to
Yeah, I'll say,
help her move in
contact
a
your
year
bar
ago,
association.
And then we were back there
But
this summer.
Yeah, you can never get in
never
trouble
give
with
a
that.
personal.
Yeah, never tell them what to do. Yeah.
Yeah. Well, thank you. It was
Well,
a
thank you.
very
It's
enjoyable
likewise for
program.
attending.
Yeah.
How'd I do?
Yeah,
I like the high five.
Yeah, and I grew up nearby.
Probably. I mean, as I usually, one of the last sections is sessions is to do one of these. And typically, you just grab the last one.
Yeah, that's what I
Because they change them every year.
Yeah.
So, and they don't always have the same topics. They have some of the overlap, like the dueling clients and. Do we have a client? I mean, that pops up all the time. Sex pops up all the time. And it was one of those classes that discussion came up. Yeah, so we'll throw this out. We'll spend the day.
That's good. So there's the CLE assignment page in the store, but I don't know specifically if there's a separate.
Yeah, well, I will certainly mention it to her. Okay.
I don't know. The way it works for me in Washington is I have to get the whole thing approved, and then I just tell them how many hours I did. I don't know what to do for it.
All right.
Yeah.
So
Then good questions.
you signed into the CLE
Yeah,
sheet.
I signed into the main. Oh, so that just.
I believe when you, then you submit things as well and specify how many.